position is that because he's been arrested more than one time, that therefore it would be a violation of the law. And I would move that to akin to when someone is arrested for more than one battery charge is based on a conviction. It's not based on a prior arrest, because again, we have a process in this country. It's a trial court where a jury will determine whether or not he's violated the law. So there are two issues with count 4 and count 5. They add language into the indictment that are not elements for a jury to consider. So they would be in violation of Mr. Bishop's rights regarding count 4 and count 5, being that they add elements that they're simply not parts of it. And so a jury would not be entitled to determine whether or not they're second or subsequent. That language should never been placed in the indictment, and count 4 and count 5 would be improper because of that. But I would also add count 3, count 4, and count 5 are all issues because, again, they don't place Mr. Bishop on notice of how he allegedly caused it. And when you look at OCGA 16-11-90 B1, in this statute, the way the statute reads is a person violates this if he or she, knowing the content of a transmission or post, knowingly and without the consent of the depicted person, electrically does that. And so in that section, it doesn't say cause under B1A.
All right, hold on.
It's
electronically transmits or posts.
Right. So it would have to fall under B2, which that's what I'm saying. It cannot be B1.
Oh, I see what you're saying. Causes the electronic transmission or posting. Okay.
Right. And so that would have to fall under B2. That's where you see the language. They cannot argue it under B1. So it would have to literally fall under B2A. And again, looking at section.
Well, it just says section D. It doesn't say.
Well, I mean, if that's the case, then but because they have the language of cause, then if the state gets to go to trial and they can argue that he did it or caused it, then that's an even bigger issue for Demira, because under that, they could argue it under the entire statute, and Mr. Bishop would have to defend under the entire statute, and that's not his obligation. He's here with his freedom, and obviously the rest of his life at issue. He would be entitled to know what code section the state is going to move under in order to effectively defend it. Are they going to argue as they've written in the indictment that he caused it? And if he did cause it, how did he cause it? Or are they going to argue that he posted it himself? And if that's the case, then their indictment is flawed just in that aspect. So whether or not they're moving under B1A or B2A, if they're alleged misdemeanors, then they would have to allege it under B1B or B2B, because that's the only misdemeanor section for that. That's not what they've alleged. They've alleged what would be under B2A, because to post to this social media website, it's to a website, is exactly what they've listed. And so simply put, it's a felony. But again, it doesn't place Mr. Bishop on notice as to how he caused it. And so that's the issue with the indictment. That's why it's subject to the mirror. We're not arguing regarding count 1 and count 2, but counts 3 through 5 are all subject to this demurrer. And they also, in 4 and 5, add language that is not in the jury's purview, because they make certain assertions and conclusions that a jury has to determine whether or not this is a subsequent violation of the law. That actually just deals with it. It might as well be say that Mr. Bishop is convicted, because again, if you put that in front of a jury on a felony battery case, for instance, it still wouldn't be for the jury's purview for that. And so I would argue that that's an issue for the state.
Okay, thank you.
Thanks, Judge.
Response?
Yeah. Yes, sir. May I approach? You have the statute in front of you.
I have the statute.
All right, so first things first, the cause issue. I'm sure the court knows the case law around special demurrers, but Wyatt from the Georgia Court of Appeals, State versus Wyatt from 2014 is 295 Georgia 257. Sorry, 295 Georgia 257 from 2014. That's sort of the case that is always cited to. The true test of the sufficiency of an indictment to withstand the special demurrer is not whether it could have been made more definite and certain, but rather whether it alleges the underlying facts with enough detail to sufficiently apprise the defendant of what he is what he must be prepared to meet. In this case, we have the date, the length of the video, who is depicted in the video. In Moore versus the state from Georgia Court of Appeals from 2023, 54, Georgia Appeals 145, an indictment charging a violation of a statutory offense shall be deemed sufficiently technical and correct if it describes the offense in the language of the statute or so plainly that the nature of the offense may be easily understood by the jury. An indictment comports with constitutional due process and is sufficient to withstand a special demurrer if it contains the elements of the offense charge, sufficiently informs the defendant of what he must be prepared to defend against, and in the event of another prosecution for the same offense, enables the defendant to accurately determine whether he may plead former conviction or acquittal. In that case, counts 1 and 2 tracked the language of the applicable statutes, alleged all of the elements of the offenses charged.
He's only raising the demurrer as to counts 3.
Right. I'm sorry. I was quoting from the Moore case,
okay.
where in that case, Mr. Moore was raising an issue with counts 1 and 2. I think, and I'll be brief, but I think one of the most, or a relevant case to this is a recent case from the Supreme Court, Eubanks versus State. That's 317 Georgia 563. Ms. Eubanks was convicted of felony murder, and the predicate felony in that case was possession with intent to distribute of heroin. The facts of Eubanks are that Ms. Eubanks was a caregiver for a disabled adult, and that disabled adult came into contact and ultimately overdosed from heroin that Ms. Eubanks was keeping in her home to sell to other people. And the indictment in Ms. Eubanks' case charged her while in the commission, and I'm quoting, while in the commission of the possession of heroin with intent to distribute, did unlawfully cause the death of the victim by exposing said person to heroin while in the commission of the distribution thereof. She raised essentially the same issue that the defendant in this case is, which is that the state did not adequately explain how Ms. Eubanks exposed the victim in that case. And the court in Eubanks, again, this is December of last year, 2023, the state need not allege all of the details of the crime in an indictment so long as the allegations contain enough detail to allow a defendant to prepare his defense intelligently. The state did not allege precisely how or when Amy was exposed, in quotes, but doing so was not required to satisfy due process. And then the court pointed out the indictment protected Ms. Eubanks against the dangers of double jeopardy in a possible future proceeding, and informed her that the charges arose out of the conduct that resulted in Amy's death. And given that it cannot be reasonably argued she is not protected from the dangers of double jeopardy. So in this case, the state alleged that he caused the posting. We have specific videos that he could not be subject to prosecution for the same conduct in the future. And he is sufficiently on notice that how, when, where the posting took place that forms the basis of counts 3 through 6. With respect to the second argument, subsection B1A deals with websites that advertise themselves as pornographic websites. A website, peer-to-peer sharing site, thumbnail gallery, movie gallery post, linked list, live web page, or message board that advertises or promotes its services as showing, previewing, or distributing sexually explicit conduct. That's why the state is, Twitter's, for all of its flaws, is not a porn site. So that's why the state's not operating under subsection B1A. We're operating under subsection B1B, which is to post such a post to any other electronic means which does not fall within subsection A, such as Twitter. So because of that, then the punishment portion is C1 rather than C2, right? And C1 makes a person who violates that subsection guilty of a misdemeanor of a higher aggravated nature, provided, however, that upon a second or subsequent violation of this code section, he or she shall be guilty of a felony. Subsection 2, which is right below it, written at the same time, dealing with posting this stuff to porn websites, says, for their recidivist portion, upon the second and all subsequent convictions. So if the legislature had intended a prior conviction to be necessary to elevate a second or subsequent offense under C1 to a felony, they would have used the same language they used in C2. Instead, they didn't, and they just said violation. Furthermore, because of the Supreme Court of the United States decision in Apprendi, which says any fact that enhances punishment must be alleged in the indictment and proven beyond a reasonable doubt, the state was required to allege that that counts 4 and 5 are second or subsequent violations, or else we would have run into an Apprendi issue. The only exception to Apprendi is when the aggravating factor is a prior conviction, which subsection C2 does not require. I would just say the information, just to get in, I don't know how deep into the facts we need to get, but I think that the evidence will show at trial that this was a website or a Twitter account for which multiple people knew the defendant's credentials to log in, password, but that nothing was posted without his permission. So I don't think that the state would be able to, it's not that we're holding information back, right? It's that this is what we have to allege in the indictment.
Okay, understood. All right, reply.
Sure, Judge. So I would love for the state to say, because what they first just told you, Judge, is that they're moving under B1A. So if they're moving under B1A, why are they using the language under B2 where it says causes? B1A is the allegation. And they also said that it has to do with a pornographic website. And B1 does not have any language in it that says that it has to do with a pornographic website.
Hold on, I thought he said he was moving under B1B.
He did. Okay, B1B rather. He said he said he's moving under B1B because B1A requires it to be a pornographic website. And there's nothing in that language under B1A that says a pornographic website. Despite that, the indictment says that they're using B2, which uses specifically the words cause. It's right there in B2. They're moving under B2. So under their allegation in, let's say because B1A, they're saying we can't move under that one, so we're moving under B2B is what they would be alleging, because under B2B, there's a cause action, which they're saying that Mr. Bishop, I guess factually, he caused someone to do that. And so even though they won't tell us who that is, but that's the allegation. So based on that, if we want to use that he can't be tried for it again, he would be open to it, because they could say that he caused Jill, Jane, Mary, Tina, Bob, Bill, or any number of people to act on his behalf in order to promote this. And he can't defend against any of it, because none of those people do we know exactly who they're saying that it is. I mean, withholding it, it's not about withholding evidence. A defendant, we got years and years of people's lives that we're dealing with here. The state has to state in the indictment what they're moving forward with and what they have to prove. And in this case, they have left us amiss on counts 3, 4, and 5. They're again saying that they're going forward on the B1B, but yet they have the language in the indictment of B2.
Hold on. I don't see B2 in the indictment. I see B.
They did, Judge, but they put the words cause. And so cause deals with B2, whether it's B2A or B2B. That word cause is in counts 3, count 4, and count 5. And so I don't know what case that can say, because again, if we're just going to say B, then under B, it could be any of these things. So that way we can say cause or, posted himself, but it still doesn't place him on notice as what he's defending against. And interested enough, Judge, I'm a YouTube nerd myself. And when I'm at home or in the car, I actually watch the Georgia Court of Appeals, Georgia Supreme Court oral arguments. And I love the oral argument on Eubanks, even though the defense lost that. But that case, the issue was proximate cause, it was not for purposes. I watched it. And I just flip it. I can tell you that case is about proximate cause. It's not about per se the indictment. And it in no way reflects the indictment in this case. In this particular case, whether you look at any of the cases that the state has put into issue, particularly Wyatt, in that case, the defendant still would be entitled to know how he is to defend himself. And so at this point, I would just ask the court to reflect back to where Mr. Coveney was up here. He said that he caused. He never said specifically how he caused it. And so we still don't know. And we're entitled in that indictment to know how he caused it.
Do you have any case law on this particular argument?
I can get some.
Now would be the time to have.
Well, I don't. I didn't know we were going forward with the mirror this afternoon, Judge.
Okay.
So.
All right. Mr. Coveney, anything else to add?
Well, in Eubanks, the special demur was raised. It wasn't the focus of the oral arguments, but it was focus of part of the opinion. And I think he's right that it's under the, I think I misspoke when I said B1B, it's B2B, but it's just the same issue, because when I said that, I was talking about the recidivist sentencing. So I don't think that makes a difference.
Okay, well, the causes, I mean, absent any case law that says that they have to specifically outline how he caused it to be posted or transmitted, I'm going to deny the demur. I think the state has provided sufficient information to put the defendant on notice of what the charges are and what the improper conduct was. So I'm going to deny the demur. If you find some case this evening, Mr. Becker, that says I'm wrong, please bring it to me, to my attention in the morning.
Okay.
But you know, under the Apprendi case, they have to allege the
Apprendi case doesn't have anything to do with that one, Judge.
not that part, the other part.
Yeah,
Apprendi, it has to do with including the language
Right.
about the felony versus the
and
misdemeanor.
so it has nothing to do with
Right.
the defendant on notice. The Apprendi case is not in on point with that.
No, but I'm just saying, my ruling addresses both issues, because there was an argument that the fact that he included the language was prejudicial to your clients, I believe, so I want to make sure that the order reflects the Apprendi argument with respect to that issue.
Well, the issue would still be under a case, for instance, for a defendant would be under a case, for instance, a defendant who's charged with battery, Judge. I mean, John who's charged with hitting Jane on Monday and then charged with hitting her on Friday is not charged with a felony at this point, even though it's a second or subsequent act of battery. So we still fall in the same thing. I understand the court's position, but I'm just telling the court that, you know, we're in a position where they're putting elements in the indictment that are not actual elements for a jury to consider that would be prejudicial to the defendant. But if that's the route we're gonna go, that's the route we're
All
gonna
right, Mr. Coveney, do you want to respond to that?
The difference is in the statute, right? 1623.1, which addresses battery, requires a second or subsequent conviction to make it a felony. That's why they would put it in.
go. And so does this one. That's how we're gonna go.
Sir, let him finish. One thing we're not going to do is we're not going to interrupt each other. I promise I give everybody an opportunity to be heard.
Yes,
Okay.
ma'am.
All right, Mr. Coveney, please continue. So the
That
statute,
was-
battery statute requires,
A prior conviction, whereas this does not.
okay. Mr. Booker, you disagree with that?
I do, Judge, because the statute requires a prior violation in order for it to be a felony according to the state. It's the same thing, same thing. And
Well-
I do want to apologize to Mr. Coveney to the court. It wasn't my intent to speak over him.
No, that's fine. It happens. I understand. It's okay. I just want to remind everybody, it's late. You've been doing this all day. I just want to remind everybody that, I promise I will give everyone an opportunity to be
I
heard.
appreciate that.
Okay, but in the battery statute 16.520.1,
23.
23.1, it specifically uses the word conviction, correct, Mr. Coveney?
99%.
Okay, let's double check. And this uses the word violation. So again, operating under the legislature intends what it says and that type of argument. I think assuming that it's six, let me pull it up.
He's correct, Judge. It does say
Okay.
conviction under 16.523.1E. it uses the word conviction.
Okay, and in this statute that we're talking about now, 161190, it does use the word violation. So
And I think that we're splitting hairs on a violation and conviction, but I guess.
maybe we are, but I have to go with we have to go with the fact that the legislature, I have to presume that they intended what they said.
That's right.
So, all right, given that, the demur is denied. And can we do the other hearings tomorrow before the witnesses testify?
Yes, Judge. We would ask that the court review the audio of the,
Okay.
we could just tender that
Sure.
evidence now if you want to. Yes.
Okay, do you want me to listen to it now?
No, we're hoping that you would do homework tonight, so it'll save us time. Of course, I'm sure you have a, maybe not. We were trying to save the time on the hearing, Judge, by, I think it's the first.
Do you have an electronic copy? Because I don't have anything that will play that.
We can do it.
20 years ago, I would have,
We can
but,
do it in the morning, Judge, it's fine.
or just,
Also, the answer is yes. I mean,
Okay.
Ms. Thomas does.
if you would email me the digital version of that, I'll be happy. How long is it?
The recording itself is about 58 minutes, I believe, but only the part up to where the Miranda warnings are
Is what's
read
relevant.
is what, at least the state's position, that's all that's relevant. I don't believe anyone disagrees with that, but I'm not.
Mr. Booker?
Yeah, I know this.
Okay, so I can listen up until the time the Miranda warnings are read, is what you're saying? Okay, happy to do that this evening.
With that, do we need Detective Panosian to come back, or can we also have a written Miranda waiver we are going to tender and
Judge, I'm just gonna say this out as advice of caution. In any case, I think it's bad practice on the defense attorney's position where we don't have a.
Of course.
So I just think it's that one.
Can't we do it prior to the witness testifying, though? In other words, I don't think we have to, it
I'm
has
fine
to.
with that.
Okay, let's do that, and then we'll just try to coordinate it so that we do it when the jury's taking a break or something, but, we'll do it prior to the witness testifying as the Daubert issues prior to the witnesses testifying.
Okay. So
Will that work?
we're not gonna do Daubert for the first witness in the morning.
Oh, is that the first witness you're gonna call?
no?
Okay.
We have one of our experts is intending to testify Friday morning. That is the one with scheduling issues, so he has to go Friday morning regardless of where we're at in our case. So he will need a Daubert hearing before his testimony, and then the other expert will be our last witness, so that could be as late as Monday morning.
Okay. So we could do them, are you gonna be mentioning anything about the testimony?
I'm not going to be mentioning anything about experts or expert testimony in my opening statement.
Okay. All right, with that, then I think we're okay in holding off to doing the Daubert hearings to immediately prior to the witnesses testifying. Okay, all right. And remember, 9:00 tomorrow morning, as the jury comes in, we're gonna do that Rule 22 hearing tomorrow. He's here, hello. Told you we weren't gonna be able to get to it till tomorrow. But we will definitely do it at 9 a.m. And I explained, my JA explained to him that I cannot, grant or deny the Rule 22 until I get more information about the process and what, how it's gonna logistically work. So we will deal with it first thing tomorrow morning, I promise. Okay? All right, anything else?
No, Your Honor.
Okay. All right, thank you all. Have a good evening. We'll see you tomorrow morning.
Thank you.
And just email me that digital.
I just did, Judge. Thank you. You're welcome.
Okay, so that was the end of day one, and I'm so glad I kept the website running even after I ended that first video, because something told me that eventually they would be back, but I didn't want to just keep you guys in here sitting listening to that whatever that music was. But you said nature nut. That person in the chat, I think that's the second troll of the day. So I did delete. Can I remove this comment? Delete. I did remove that troll. We had another troll in here who was going cray, and they said they weren't. They said in somebody else's chat for me to please unblock them because they're not a troll. And I was like, well, if you're not a troll, why do you keep saying the same old thing in my chat, which was the R word? And you weren't just saying the R word, you were spelling it out, RAPE. But anyway. Child, these people's going crazy. The Natureboy sector is up in arms. They is lit, lit. Okay. Everybody right now over there in the Natureboy sector, they just like a lot of us have been looking forward to, the trial. And it is here, day one of the trial. Now I did get some court docs from the county, but child, they got some they got one that's really big and it's a lot of pages, and I was not about to pay for, man. I was like, dang, should I pay for this? Because it's like 50 cents a page. And some of the things was only like 2 pages, 3 pages, a few pages. But yeah, a lot of them, one of them was like 100 and something pages. And I was like, I don't like Natureboy that much to go ahead and pay that. So maybe some of y'all can go ahead and pay it and talk about it on y'all channel. And then I will go ahead and do commentary off of y'all. But yeah, what Byron Lowe said, they came right when it was time to go home. Yes, they came right when it was time to go home. I was like, what is going on? It's like about to be 5:00 p.m. Ain't nobody trying to be up in jury duty all day as it is. And then y'all up in here got me after 5:00, like 5:00. That's when I should be going home. Shoot, by my hours, by my work schedule. But that jury duty stuff, that is. Somebody said in the chat earlier in part 1, when we went live earlier, they said in part 1, these jury members have no idea what they are about to get into. And yeah, some of them don't, but some of them do. So let me show, let's see. Let me see if I can pull this over here. Let's see. Oh, I guess I gotta open it up. Wait a minute. I don't want to show all the jury members' names. Okay, I think this is it. I hope y'all can see that. Okay, you should be able to see that pretty good. Let me remove all this. Okay, so this was filed on the 9th. And basically, this is the... Dang, what happened? I made it go small again. Oh, I see what I did. Okay, my bad. Okay, here we go. Back to page 1. Okay. Amended General and Special Demurrer, the state versus Eligio Bishop, case number 24CR1183. Come now, Eligio Bishop, by and through undersigned counsel Robert Booker, and move to the court to grant the instant general and special demurrer and respectfully prevent the following to the honorable court. You know what? I'm going to pull this up on a picture because I don't like how it's shown on here. So that's what I'm going to do. Let me see if I can. Hold on. Because I don't like to save it like this. Oh my God, my neighbors are out there making so much noise. It is like 60 something degrees here, y'all. It's like 60 something degrees here, y'all, and everybody is out with their music. Hold on. Let me plug up my laptop. Okay. See if I can save this in a pit. Natureboy. Matter of fact, I think this is a different one. They were just talking about the Dalbert, like right before they finished. I don't know if y'all heard them say that, but they was just talking about that. So let me pull that up. Okay. Hold on, y'all. I guess that's the best way for me to show it, huh? Oh, well, I guess that's the best way for me to show it. So let me go back to it. Hopefully y'all can see that. Get your glasses on. Okay, so as I was saying, okay, that should be better right there. Yeah, that should be good enough for y'all right there. Okay, so come now, Eligio. We already read that part. The state charges the defendant with prohibition of nude or sexually explicit electronic transmission. This sounds kind of like what somebody in the B sector just did recently. With the offense of prohibition on nude or sexually explicit electronic transmission and violation of OCGA 16-11-90B. The said accused person in the county of DeKalb and state of Georgia on or about the 27th of March 22, without the consent of Janae Newell, the depicted person, his ex, did unlawfully cause the electronic posting of a certain video with a length of 28 seconds with the knowledge that it depicted sexually explicit conduct of Janae Newell, an adult, for the purpose of harassment, and such video served no legitimate purpose to the person depicted. This offense constituting a second or subsequent violation of this law, contrary to the laws of said state, the good order, peace, and dignity thereof. The state, part 2, the state fails to place the defendant on notice as to how he caused the electronic transmission or posting. As a result, the defendant requests specificity, whatever, and how he caused the posting of the video. And we heard that earlier, maybe 20 minutes ago. They were talking about anybody could have used this computer. A lot of people had his password to his Twitter account. So basically, how can you prove that he was the one who posted it on there, right? Okay. So anyway, they said they want to show how he caused the posting of the video so he can properly prepare for his defense. Furthermore, in the last sentence of count 4, the state includes the language that this offense constituting a second or subsequent violation of the law. The defendant has never been convicted of violating that law before. Da, 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 da. Okay, count 5. With the offense of prohibition or nude or sexually explicit electronic transmission. Did we already read that? Oh, we already read that. Okay. Okay, that basically just says the same thing. All right, so that's one thing right there. The other thing was a bill of indictment. It basically shows the grand jury selected, chosen, and sworn for the county of DeKalb to wit. It looks like 1, 2, 3, 4, 5 people were removed from the jury selection. 5 people were removed from the jury selection. So out of all those people that we saw, it looks like 5 of them was removed from the jury selection, and that was for the preliminary, by the way. That was for the preliminary. Okay, now let me see what this one is. It is so much. Okay, now here's the Dauber one. Okay, let me pull up the Dauber one for you guys, because that is basically where they ended at on the Dauber one. Let me see. Is this it? Yep, this is it. Okay. All right, let me make it big. Okay, now this was filed on the 15th. Defendant's motion for Dauber hearing. So that's what they were just ended up on. His attorney had just ended up on that, talking about that with the judge. And then they also gave her something that they wanted her to watch, and he asked for her to watch it overnight. She was like, could y'all put it on like a drive or put it on something? Maybe upload it on YouTube so she can watch it, because like she said, maybe 20, 30 years ago, I would have been able to put, but anyway, technology. Everybody doesn't change with technology, and we can see that in this case with the judge, because she's like, and how am I supposed to watch that? But it says the DA's office has recently provided notice of intent to call 2 witnesses, which would be requested to provide expert testimony. The government has the burden to establish the admissibility of an alleged expert testimony. And as they found in Dauber, his consequent decision at Kumo, this is exactly what they were talking about. This is it right here. So basically, they're saying upon motion of a party, the court may hold a pretrial hearing to determine whether the witness qualifies as an expert and whether the expert testimony satisfies the requirement section of this code. Because, hold on, right here. Oh gosh, I just had that up. Let me see if I still have it up. Oh, it had one of them in particular. Hold on, let me go back over here, because I still have the website up. Oh, I hope y'all cannot hear my neighbor's music. They is out there like it's summertime. Let's see. Amended list of witnesses. Is this it right here? Stay here by no defendant and expert. Okay, yep, here it is. Okay. So let me pull this up for you guys. Remove this one. Sound like some, I don't know what kind of music they playing outside. Ooh. But it's irritating to my ears. Okay, here go one. All right, so when they came to the Dauber, they were talking about the witnesses. So, can we get this bigger? Can y'all see that okay? Let me see if I can make it a little bigger. I just don't want it to get out of... Okay, so it says, Superior Court, State of Georgia, Burton Eligio, of course, notice of expert testimony, Amanda Planker, maybe? Anyway, I might be saying her name wrong, but anyway, the state hereby notifies the defendant that it intends to call Amanda Plankert as an expert witness in domestic violence and trauma. The state expert Amanda Plankert to testify regarding the trauma response as it pertains to reports of sexual assault, domestic violence, and common patterns of behavior and misconceptions as they pertain to sexual assault and domestic violence. Other possible topics of testimony include her training and experience in the field and research and literature upon which best practices has been developed. Now that's one. There's another one. One second, let me pull up the other one. Okay, that was a man. Okay, here's the other one. I just gotta close this one and pull up the other one. Let's see, is this it? Okay, here's the second one. Let me make it a little bigger for y'all. This is another one of the witnesses. I think that's about as big as it's going to get. Sorry, y'all. But it says, notice of expert testimony, Rick Ross. The state hereby notified the defendant that it intends to call Rick Ross as an expert witness in coats and coat dynamics. Now, this is going to be interesting, okay? So I can't wait to listen to him. The state expects Rick Ross to testify regarding coats, coat leaders, coat dynamics, to include the means by which coat leaders obtain and maintain control over coat members. Further topics of testimony may include common patterns of behavior and misconceptions as they pertain to coat members and former coat members. Other possible topics of testimony include his training and experience in the field and the research and literature relied upon within the field. That was submitted on the 8th. I think that other witness was submitted on the 8th as well. So this guy, I know the other lady, she's going to be testifying due to trauma from being assaulted, the R word, things like that. And then this guy, he's going to be an expert witness on coats. So I guess, his background, maybe he's been studying coats and coat behavior, former coat member behavior, for a long time, but it says he's an expert witness in coats and coat dynamics. So again, I am very interested to hear what he has to say when they put him on the stand. Especially, child, what's up, Big Man TV? How you doing, love? Thanks for tuning in. We're on the tail end of the day one of the, jury selection for the Natureboy, aka Eligio Bishop's trial. For the people who are maybe behind or maybe don't know exactly what is going on with this guy or who he is. But anyway, he is a cult member. Eligio, aka Natureboy. He is a cult leader facing charges including rape, false imprisonment, according to the DeKalb County DA office. He is 40 years old. Well, he's probably 41 by now. No, he probably is 40 right now. He ain't that old, but still old enough to know better. Anyway, they're accusing him of leading a cult called the Carbonation Group. So if you ever heard of the cult Carbonation, their leader was Eligio Bishop, aka Natureboy. A former member of the cult who identified herself as his girlfriend said he posted revenge porn because she left him. Police reports detailed that the woman told authorities that she had joined a sex cult, not just a regular cult, but a sex cult, okay, in which her boyfriend is the leader, and that she did live together with Mr. Bishop, and he posted sexually explicit videos of her and him without her consent on Twitter, now the social media platform called X. Later, Bishop's wife and former cult leader told 11 Alive he had sexually and emotionally abused members. According to the Costa Rican news Okay, y'all remember that shit when it was popping in Costa Rica, right? According to the Costa Rican Star newspaper, the group's history includes being thrown out of at least 3 Central American countries. Do y'all remember that? I remember one time when they boarded the plane. Was that in Hawaii? They tried to board a plane and they threw their bus off. But anyway, they said they was thrown out of at least 3 Central American countries. The newspaper reporter reported the cult believes in nudism. We all know that. They like to walk around in the nude. Polygamy, we all knew that. They be sharing and swapping spit and saliva and everything else that drips, okay, or gets wet, okay, and refraining from bathing. Do y'all remember when they was on the plane and they put the mugs off the plane because they were so funky? Do y'all remember that? They was, oh my God. Like, they probably smelled like Tarzan. No, I'm sure Tarzan. I'm sure he smelled good. Tarzan and Jane, I'm sure they smell good. But anyway, they all was funky and they all was stinky. I remember that, and they threw them off the plane. But yeah, they said they like to refrain from bathing. They said Bishop, aka Natureboy, also had a huge following of tens of thousands of followers on Instagram and YouTube, which we know about. They also referred him as the 3 God, which we know about, and he projected his messianic self-image, Masonic self-image. So today, on Wednesday, potential jurors will ask questions, including, and we discussed some of these in part 1. Some of the questions was, does everyone agree that victims of sexual assault sometimes don't disclose their assault immediately? One of the other questions was, is anyone here or a close friend of a family member in a relationship with a controlling or dominant person? And we heard a lot of them say yes. Some of them said they have been in one. Some of them said my mama, my grandma, my great mom, my auntie, my daughter, my sister, my cousin, them. Another one of the questions was, is anyone familiar with or think they might be familiar with the defendant through his presence on social media? That could be Natureboy TV, aka Carbonation TV, or any other way. Opening arguments for the trial are set to begin Thursday at 9 a.m. Are y'all looking forward to this, y'all? 9 a.m. Today, February 21st. Trial set to begin with the motion hearing and jury selection. That was today. All right. So basically, in July 2022, a grand jury indicted Bishop on rape, false imprisonment, and 3 counts of prohibition of nude or sexually explicit electronic transmission. That, of course, is that video that he posted on Twitter of his ex-girlfriend. And again, she said he did that to her because she left him. Now, I want to read y'all something that the neighbors were saying. I read that earlier. But some of y'all probably wasn't in here for the part 1. So I want to make sure that I read that for you guys because that was crazy what the neighbors had to say. Now, his neighbors, and mind you, when they did arrest him, it was following a 3-week investigation. Now, his neighbors, this is what they had to say. Natureboy's neighbor said he was running an online cult called Carbonation. And we already know it wasn't really online. It was like in real life. But he had a lot of followers online. And a lot of the people in his cult, they was always online also, you know. But it says Carbonation is his cult. He's been whooping girls. They say he's been whipping on them girls, beating girls, fertilizing. This is what I got a kick out of. Fertilizing. This is what the neighbor said, y'all. Fertilizing girls, getting girls ready for marriage. Like they do over in the Middle East. Fertilizing girls, knocking them up, getting them ready for marriage. That's what a neighbor said. But of course, that neighbor didn't want to give their name. Now, a former rape survivor, or basically a former cult member who claims that he, gave her did the R word to her, also again said that he posted revenge porn online after she left. Um, so yeah, that's the gist of it. For people who really don't know what's going on. But if you've been stuck under a rock all these years since Nature Boy has been around, we're talking before 2022. We're talking before he was indicted. We're talking when they was roaming around in nature, walking around booty bucket naked. Like, I mean, child, I always never could understand. I could never understand. Just even a regular cult where it might not be a sex cult, but it's just is it regular? Is a cult even regular? But y'all know what I mean. A cult where people actually get married, they actually go to church, they just do things, and some of the things that people might not agree on. But his particular cult was like some different. I don't know. I don't understand how they could have survived that long. And I don't understand how people are still standing in the gap for him to this day. I just don't understand it. But anyway, that former cult member, Musa, said Bishop is their God. And as a group, they believe in. Hold up. Okay, this is from an interview. Okay. Musa said Bishop is their God. And as a group, they believe in nature, nudity, and kindness. I don't know so much about the kindness because I remember times when he was locking up girls in closets. He was beating them. He was doing that on live, putting his hands on them on live. I know y'all remember that, okay? So kindness, I don't know about all that. But Musa said the criminal accusations are from a disgruntled former member of Carbonation family. She said she was here under false imprisonment. We have live documentation of when we said, hey, if you want to leave, you can leave. Nobody is forcing you to say, Musa said. Standing in the gap. Now, Bishop also has ties to Atlanta dating back to at least 2009. But around 2016, he and his followers moved to first Central America. Some of y'all was back there when I was watching him too. First moved to Central America, where they got put out 3 times. Then to Honduras, and then to Costa Rica until they were forced to leave in 2017. And 2020 reports show Bishop. Okay, this is what I was telling y'all about earlier when they went to Hawaii, right? So in 2020, reports show Bishop was arrested in Hawaii for breaking COVID quarantine rules. Remember, it was not clear to return to back here then. They was trying to return to the A. We don't know when he did actually return to the A, but at that time, it was a quarantine going on. And basically, they were arrested because they was trying to catch a flight. Y'all. But yeah, it's a lot going on in my Tracy voice. And again, a lot of people have been looking forward to this, looking forward to see if he's actually going to be, like, he's already been charged, he's been indicted, but will any of this stick? Because, just like with the Tasha K and the Cardi B things, like when things like that happen and we sit back, I'm a vlogger. A lot of y'all watching are vloggers. And what's up, Levon? Hey, thanks for tuning in again and Vibrant Low, Aisha. But a lot of us are vloggers. A lot of us are bloggers and vloggers. YouTube, IG, Facebook, social media. We got our own website. Some people got their own websites. And so some of these things that people do on here and then they go to court for, that makes like a big decisions that we have to look at and we might have to abide by also on our own platforms. So when we see people like Cardi B taking people like TK to court, and a lot of people say, oh, it ain't gonna stay, oh, Cardi B, oh, she just mad, oh, Cardi B, why she gotta take her through court, all that kind of stuff. But then people's like TK, on the other hand, she deserves it because she has just been doing too much over the years. Just too much. And a lot of things they always accuse her of was giving out false information, inaccurate information without receipts. So that's one thing that TK was known to do. And from what I hear, is still known to do. But Anyway, so again, with this thing with Natureboy, like he is well known. He has hundreds of thousands of followers all over the world. And he has been charged for basically doing something that we literally just saw somebody else do here in the B sector a few weeks ago. Has it been that long? I think it's been a few weeks. Yeah, I think it's been a few weeks. Oh my God, the time in YouTube, it just goes so fast. If you blink, you'll miss something in the B sector. But they literally did something like that. It wasn't a video that they posted, but it was some still footage. It was still footage from a video. And it wasn't the revenge P, but it was still done maliciously. And a lot of people think that person should go to jail and should be charged. I don't know. But I'm really looking forward to see what's going to happen with this case. Will he be charged and then get a whole lot of time locked up? He's already been in jail for a couple of years. Will he get time served? Will he have to pay her any money? Because as far as I know, he didn't really have a job. He always had YouTube though. He used to get a lot of money, PayPal, Cash Apps, things like that. Of course, on the platform of YouTube, of course, he was getting AdSense checks as well. Matter of fact, what's today's date? Hold up, y'all. Let me check my little account while I'm talking. Hold on, y'all. Did Google pay us today? It's the 21st. It's the 21st. Yeah. Okay. No check yet. Probably be here tomorrow. Hopefully tomorrow. I know the checks start coming on the 20th and they get handed out like between the 20th and the 21st. 20th and 24th, something like that. But if y'all didn't get y'all check yesterday or today from Google AdSense, check back tomorrow. Check back tomorrow. Because they don't deposit during a certain time of the day. It just can be random. Anywho. That let me get this off the screen right quick. I think those were the only things that I want to show y'all as far as like paperwork, as far as documents. So we got those two expert witnesses, Rick Ross, who's going to be the key expert for cults and cult dynamics. Again, he is going to testify regarding cults, cult leaders, cult dynamics to include the means by which cult leaders obtain and maintain control over cult members. And then also that the other witness, the other expert witness. Let's see. One second. What was that other expert witness name? Because here it is. Her name is Amanda Blanchard. Okay, Amanda Blanchard is another expert witness that they are going to use in domestic violence and trauma. And she is going to testify regarding the trauma response as it pertains to reports of SA, DV, and common patterns of behavior and misconceptions as they pertain to SA and DV. Okay, so they were talking about the Dauber earlier because they want them to have like a preliminary. Let me see if I still had a Dauber up here. Okay, so the DA office has recently provided notice of the intent to call those two witnesses that I just spoke about to be providing expert testimony. Okay, so to determine the admissibility of the expert evidence, trial courts must consider whether the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. The testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods. And D, the expert has reliably applied the principles and methods to the facts of the case. So, upon motion of a party, the court may hold a pre-trial hearing to determine whether the witnesses qualify as an expert and whether the expert's testimony satisfies the requirement of subsections A and B. A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. And again, B, the testimony is based on sufficient facts or data. that is very important for any trial. When you have expert witnesses, they just can't have anybody on there, trying to testify, especially when somebody's looking at some serious time for some serious charges. So they definitely have to make sure their testimony is based on sufficient facts or data. Okay? All right. So we got that established. Now, let me stop that screen. And I think that is, yep, I think that is it. Those are the only paperwork or documents that I wanted to show you guys. As more documents come out, as the case, moves forward, I might get y'all some more documents, okay? So I can give my expert commentary with facts, okay? But yes, again, this is part 2 of day 1 of the beginning of the jury selection for the trial for Eligio Bishop, aka Natureboy. All right. So thank you guys for tuning in. Make sure you like and share the video. The trial is going to kick off tomorrow, y'all. And all over the vlogger world, the vlogger. See, we're vloggers. And I'm actually a blogger too, because I do have my own website, thehoodtable.com. And sometimes I do write up some stuff and type up some stuff and put it over there. So I do blog from time to time too. But yeah, we're all vloggers basically over here on YouTube. So the vlogger YouTube world is about to be lit. They was lit today, but it's about to be lit. So I hope you guys enjoyed part 1 and part 2 of this show. What I'm going to do is, with part 1, I'm going to edit that one because they had some large gaps in the jury selection where they was taking these extra long breaks. And it was just nothing. We were chit-chatting, throughout some of it, but a lot of it was like nothing there. So I'm going to edit that first video, part 1 of day 1 of the jury selection, so that, it just runs smoothly. Just the court proceedings and the jury selection just run smoothly. So if you catch that on private, that is why, because I'm editing part 1. But this video right here is going to stay just the way it is, all right? Again, like, share the video. Hit the Cash App if you want to contribute to the platform. $ the Hood Table 402, please and thank you. And stay safe, be blessed, remain vigilant at all times, and always remember to keep it hood. I'm out.